Hi, we're going to look at some questions on conflict of interest. Let's start off with current clients versus current clients. This conflict is never consentable in the same litigation. If client A and client B want to sue each other, they are both the lawyer's current clients. The lawyer cannot represent them in court because he will be in both sides of the litigation for one and against the other, and that is never possible. So, not consentable. Situations of transactional matters. So it's important to realize when it comes to litigation and transactional matters. If it's a transactional matter, the lawyer can represent both because it's just transactional. For example, a lawyer representing a lender and a borrower in transactional matters for as long as Rule 1.7 is complied with, which is the lawyer has to have a reasonable belief that he can provide competent and diligent representation to both. It's not prohibited by law. There's informed consent from the parties. Class actions, no consent is required when a lawyer is defending or representing a plaintiff, in this case, in a class action for the unnamed class members. Business transaction usually happens when the lawyer is making a business deal with a client. So, on top of being the lawyer of the client, the lawyer is engaging in a business deal with a client. For example, if he borrows money from that very client, he buys his house or his home, lends money to that very client, opens a business together. If that is the case, the rule 1.8 has to be followed, which is transaction has to be fair in writing. The client needs to seek independent legal counsel, and there has to be informed written consent. Standard commercial transactions are situations where a lawyer sells something in the marketplace and the client is a regular purchaser or customer of the business of the lawyer. So there's no exploitation of his position as a lawyer in this case. There's no reason for Rule 1.8 to be adhered to because that is just a regular business deal without involvement of the lawyer as a lawyer. Proprietary interests are usually prohibited. It is when a lawyer wants to acquire an ownership interest in a client's lawsuit or litigation. For example, a client sues to recover $1 million and the lawyer wants half of the money. That is prohibited. Exception is in situation of contingent fees where the lawyer will be paid when the lawsuit is resolved, and situations of an attorney's lien, which is then up to be paid after the fees, in this case, of the case are solved and then the attorney is paid.